Okay, welcome everyone to Protect What You're Building, a practical guide to intellectual property for business owners. We have Jason Toomey with us. He is a Boston business mentor. He is what we call an SME, which means he generally works with other mentors and their clients on very specific topics. So we're very pleased that he can share his knowledge with us today or with our clients today. Um, as we get going, though, I would definitely like to tell you a little bit about Boston Business Mentors just to make sure you're taking full advantage of everything we have. As you know, because you're here today, workshops and webinars, a significant part of what we do. We have in-person workshops, we have roundtables, strategy groups, we have networking opportunities, and our webinars. Everything is advertised through our website, our newsletters, and social media. We are always adding new topics. So if you just looked at it last week, there's probably another new topic that's been added for this week, going forward. So look at that. Information, our website, resources you can look at, templates you can download. I'm going to call your attention to the blog section. Under the resources, lots of really fantastic articles put together by our mentors and by our partners. They're very timely topics. Some of them are even industry specific. So I take a look. You can do a search on them and see which topics apply to you. There is no doubt what is most important, I think, at the heart of all of our volunteers is our mentoring opportunity. Our mentors are free, so mentoring is always free. Mentors can be and fill different roles for you. They can be a sounding board. They can be someone that can help you overcome a challenge that you've recently come across. They can help you plan for your goals. Can fill many different roles, and our mentors have a variety of skill sets. They've learned from their life experiences, and they're ready to help you. So if you've never had a mentor, everyone, it's a great experience. So consider that as an option. So I'm going to go ahead, pull this down. I do want to encourage you as Jason gets ready here. I'll turn it over to him here for in a moment, but please ask questions. This is your opportunity to get your answers right now on this topic. So do not hesitate to put your questions into chat, and we'll get them answered at the appropriate time. So Jason, I'm going to go ahead and introduce you and let you take over.
All right. I'm sorry I'm giving you guys a little preview here. It wasn't at the top of my slides. Hopefully, I am sharing the right screen. Does everyone see the title slide? Does that look coming through okay?
Yes,
All
we
right,
do.
wonderful. All right, hey everyone. Thanks so much. Thanks to Boston Business Mentors. I'm really proud to be a part of this group and helping out how I can. I love what they do. And what I want to talk to you today for a little lunch and learn type session is really a practical guide to intellectual property. And I'm really aimed at this at business owners. All right. So really what you need to know about intellectual property. Now, I just want to do a quick caveat. Usually I can there's like four different sections of intellectual property we're going to go through today. I could spend 2 hours talking about each and barely scratch the surface. So we're going to do a very high level overview and really business owner centered focus on this. But as always, if you need more, I'm going to give you resources for how you can get more information on those things. Just before we jump in, and this is the noisiest slide. Sorry about the most lawyerly slide that I have. I promise. Um, Little quick disclaimer, everything we're going to be talking about today is information only, right? I'm not giving legal advice. I'm not creating any attorney-client information with you. This is just general advice on how to on sort of a background on how IP works. If you need actual legal advice, I highly encourage you to talk to us, talk to a different attorney. Don't use Google, don't use ChatGPT. This stuff is too important. You're going to see why. But I'll have my contact information at the end too if you want to do some follow-up questions and ask some questions during the session. Okay? All right. That's out of the way. Who am I? Why am I here telling you about intellectual property? So I'm the owner of IntelliState Law. We are a small practice focused on asset protection. So for us, that means a lot of intellectual property. I'm a registered patent and trademark attorney with the USPTO. It means I'm licensed to practice before the USPTO and actually file patent applications, manage trademark applications. I have over 20 years experience in IP law. Before I was in IP law, I was actually an electrical engineer. That's how I started my professional life. Last thing I developed got patented. And I heard the song, the siren song of law, and I kind of jumped over to that side and I loved it. You'll see, I get very enthusiastic about this kind of stuff. Um, Most of my career was inside a small Boston tech startup. So I know small business. I know what it's like to manage intellectual property, on a budget and do it effectively. And you're going to see a lot of the information I'm going to give you today is kind of from that. And right now, my firm, we are focused on helping small business owners really protect what they're building. That's really what's important to us. And that's why we're so happy to work with Boston Business Mentors. And I'm happy to give back as much as we can. All right. So a little bit about me. I like to just sort of set that context. What are we going to talk about today? All right. So really, what we're talking about is how to protect what you're building, right? And where most people get it wrong. So I want to talk to you about what intellectual property actually is, right? What are the four main categories of intellectual property? We're going to go through each one of them. What you can handle on your own versus when you need to get help. I think that's really important, especially for my small business owners, right? What can I just do? Or when do I need to hire somebody? It's good to have that distinction. Where are you going to commonly make mistakes? Probably the biggest thing we can talk about. And I want you to really think about intellectual property as a business asset, okay? Not just legal protection, not just a thing I get to hang on the wall, but your intellectual property, we're going to talk a lot about this, is just as valuable as your building, your truck, your tools, the products on your shelves, right? It's incredibly important, incredibly valuable, and I want you to understand how it works, okay? So that's really kind of setting the context of where we are. So let's start off with what is intellectual property, okay? And let me get this out of the way. I say IP a lot. It's just drilled into my head. So intellectual property is IP, and that's kind of the buzzword that we use. So if you hear me saying that, that's what I mean, okay? All right, so what is intellectual property? Well, let's start with what it's not, okay? It's not your tangible property. It's not the things that you can touch and hold and see in the parking lot or see in your shop, right? It could be like the building that you own, right? Could be like the truck that you own or the car or something like that. It could be the tools that are used in your business, right? The things you can touch. And that's very easy to see. These things are valuable. I went out and I paid for them. And if you walked out one morning, if you walked into your office one morning and all of your tools were gone, your computers weren't there, you would know what to do. You would say, my valuable things that I need to run my business are no longer here. I need help to get them back, or I need to take steps to protect and make sure that doesn't happen. Most folks understand how to do that, right? But what is intellectual property? Well, it's the intangible property, right? And it's still a critically valuable business asset. It's still incredibly important, right? It's the ideas and the know-how, right, that you have, the things that you know how to do, the things that you do differently than anyone else has done before, right? That's really important. It's a really valuable business asset, right? It's the printed material, the copy, the stuff on your website, anything you're sort of any kind of expression that you're reducing down to tangible medium. These are incredibly important, valuable aspects of your business, right? It's also your logo, your name, your the name of your business, your taglines you use in your business, your product names, right? All of these have value. We're going to talk about how all of these need to be protected, right? So really what we say is intellectual property, it's the part of your business that you can't touch, but it still has value, right? And that's what we mean. Okay, hopefully that's clear. Okay, and as Teresa said, questions in the chat if you want us to stop, and Teresa will stop me if I'm going over anything. All right, why is intellectual property important, right? Why are we talking about this? Well, as we said, if you show up to work one morning and your company van isn't there anymore, or your tools are gone, you know who to call, you know what to do. You know how to protect those things or how to take action if those are taken away from you. But what do you do if someone's taking your intellectual property? Right? What do you do if somebody's using your logo, your name? The someone steals the blog article that you wrote off your website. How do you stand up for yourself? What do you do? Well, intellectual property is really about giving you the power to protect your business, right? And it's really about giving you the tools you need. Intellectual property, as we like to say, gives you a property right. It gives you a right to enforce a stick that you can go out there and say, look, this is mine, give it back, stop touching it. And that's really what we're going to talk about today. So that's kind of the image I came up with for that. I had a little fun. Hope that's okay. Um, so now that we have kind of an overview of what IP is and what it does, let's go into the four types, right? So four major types of intellectual property. The first is what we call copyright, okay? And copyright protects expression, right? Copyright, we most often think about this in music, right? Books, movies, TV shows, like, oh, they've got a copyright on that, right? They had an idea and they reduced it to a tangible medium, and now it's protected. That version of that is protected. For you as a business owner, what does this mean? It means the words on your website, right? The marketing materials that you create, the blog posts and articles that you write, photos that you take, videos that you take, but even things like brochures and ads and training guides or things that you actually create, creative work that you do and actually express, that automatically gets copyright protection. We're going to talk about that. Trademark. Trademark is my favorite type of intellectual property because it's the most mysterious, right? Most folks come to me and they say, hey, I need to trademark my business name so nobody uses it. That's part of it, right? But that's not really what trademark protects. It's a lot more than just protecting your business name. I like to say trademark protects your reputation and your goodwill, right? The hardest thing that you create as a business owner is your reputation in the community or in the marketplace, right? That people know that you are the best bakery in town. People know that you are this diligent accountant who's honest and who's going to work with you and trust with you. Your name, you work very hard to get that image and that mental feeling of goodwill into the client base, and trademark protects that. Trademark protects someone from using your name, your logo, your tagline, and trying to come off as if they are you, right? And that's really what trademark protects. We're going to talk about that a bit more when we get to the trademark section. Okay, patents. Patents protect ideas, all right? We're talking about a brand new type of product that no one's ever done before, a new type of process, do something, tools or equipment that you create to do your job, right? Improvements on existing tools, products, processes, just better ways to do things. We're going to talk a lot about this, but if you have an idea, you would protect it with a patent. And then the last is what we call trade secret. Okay, this is the last category. Trade secrets, I like to say, they protect the confidential know-how. Best example that I always love to use is Coke, right? Everyone has that secret formula for whatever makes Coke Coke. Two people know it. It's locked in a safe. Now that's probably marketing kind of fluff at this point, right? I'm pretty sure any PhD chemistry student in a lab could figure out what's in Coke. But it's that idea that like they've got the secret recipe and nobody can figure it out. And rather than patent it, we just keep it as a trade secret. The KFC herbs and spices, right? Those kinds of things. Your secret sauce, we like to say. So sometimes it's better if you've got a way of doing something that nobody else knows how to do, and this is sort of your edge in the market. Sometimes it's better just to keep that a secret, right? And no one else is going to be able to copy it because they don't know it. But there's steps you have to take to make sure that you're keeping it secret, and we're going to talk about that. All right. So these are the four types of intellectual property. And what I'd like to do is just kind of spend a few minutes going through each. And as I said at the beginning, I could spend 2 hours talking about each one of these. So, and for patents and trademarks, I do actually have presentations where I do that for more deep dives. But what we're going to do is just try to do a really high level overview of each one of these, just to sort of set the table. All right. So let's talk about copyrights first, okay? So again, what is a copyright? Copyright protects expression, right? That's what we talked about. So any content you're creating, I want you to think about protecting it with copyright, okay? So website copy, photo, videos, marketing materials, all those things that we talked about. Now, what's really exciting about copyright is you get copyright protection as soon as you create the work, right? As soon as you write that blog article and hit file save, that's what we call reduced to a tangible medium. Copyright protection exists. You don't have to do anything special. Same thing with a photo that you take. a brochure that you create, anything like that. As soon as you create it, you've got copyright and you can mark it. Circle C, business name, the year, and you want to put that on there. You get that. Um, it gives you control over copying and use, right? So if someone takes your blog article, someone uses your photo without your permission, you can say, hey, stop that, take that down. I have the copyright on that. And that's why we want to mark. We mark to put them on notice that says, hey, don't download this article I wrote. This is copyright me. And you can call me if you want to use it. We'll talk about what the licensing would be. Um, so I'd like to give an example of copyright because copyright gets a little bit, I find clients get most confused. Imagine that I am out with a friend and we're having coffee and I tell her, I've got a great new idea for a story. I am so excited about this. Let me tell you about it. This is my idea. I've got this girl. She lives on a farm. She's kind of bored with life, but one day there's a storm and she's whisked away to this magical land and she meets a scarecrow and a tin man and there's even a lion and the lion talks. It's really cool, but he's kind of funny. And they go on this adventure and there's a witch and there's a wizard and there's flying monkeys and it's wild. And I tell my friend all about this story, right? I tell her my idea. Right? Then I see her a few weeks later, and she's so excited to tell me about what she just did. Hey, I just wrote a whole book on that idea you told me about, and I put the girl there and the scarecrow. I changed the lion to a bear because I thought bears are better. Bears play better. And then my daughter likes cats, so you said she had a dog. No, she's got a cat. And I'm really mad, right? Because didn't she steal my idea? Didn't she steal my copyright? This is my story, isn't it? Um, and she took it from me. Shouldn't I be able to defend this? Well, actually, this is what we mean. Copyright protects expression, not ideas, right? Copyright, the writing of that story, the actually typing the words into the page or drawing the picture or making the movie. In the business context, writing the blog article, creating the brochure, actually doing the work. So if you tell a business partner, if you tell, somebody that you're networking with, hey, I've got this great idea to get clients. I'm going to write up this brochure about how we're going to do this, or I'm going to write this blog article on this. And then they go do it. They haven't taken your copyright. So you want to, reduce your ideas down record them, do the thing, then tell people about it, right? Because it expresses the expression, not the idea. All right. Hopefully that makes sense. I love that example, and that Wizard of Oz was right from law school. That's what they actually teach it into the classes. Okay, so I had mentioned that. Oh, we got a chat. Should I pay attention to that, Teresa, or?
Someone is using your company tag to sell a product that we use to sell, but could not get the US patent on it. Oh well, I'm sorry. Yeah, I thought it was a question at the bottom, but let's.
Oh, okay, okay. Let's talk about that when we get to trademarks. That they used to sell, but cannot get US patent on. They're selling it on eBay. Yeah, this is trademark. That's not copyright. Let me get to this question when we get back to trademarks. Let's just table that for right now so that we don't derail. But that's a good question. All right. You need to register your copyright. Okay. Do you need to register copyright? Remember, I said that copyright attaches as soon as you create the work. You don't have to what we call register it with the federal government. But sometimes you want to, right? I'm out of right? Because copyright exists as soon as you create the work. But if you want the court to help you, right? If you want the court to go in and tell this person to stop using it, you need to register the mark. And you can do that just before you file the court case. That's absolutely fine. But timing matters. If you wait too long to file, to register your copyright, and we have to do it within 3 months of publication. If you don't do that, then you lose access to certain remedies, certain damages. So if it's something, I usually tell clients, if it's something that's going to be a product, right, something that you're going to be making money off of selling and copying would impact those sales, we absolutely want to register right away. If it's something else, something that you're probably not going to go to court over, we probably don't need to worry about registering it because we're not going to sue, until somebody uses it. And at that point, we just want them to stop using it. We're not really going to be fighting about damages. I'm getting to a little bit of the weeds there, but the idea is the registration is a thing that you can do. You don't have to. One other thing I'm really excited about that's brand new is what we call the Copyright Claims Board. Before 2022, I would mostly tell clients, there's no reason to file suit. Someone stole my copyright, someone took um, my blog or my brochure or something like that. What do I do? We're going to spend more money filing a court case than you're going to get back. So let's write a letter, hope they stop, or something like that. The Copyright Claims Board came up to do this. This is a small body inside the Copyright Office in Washington, D.C., and it's almost like a small claims court for copyright disputes. And it's very affordable, right? It provides a forum for those cases that otherwise wouldn't be worth taking to court. You don't even need a lawyer, though they recommend that you do have a lawyer help you, but you can do it pro se, as we say. And it's a relatively new option. So I bring this up not to have you like write this down and be like, oh, I go to the Copyright Claims Board, but just know that copyrights are now more valuable than they used to be, right? Because you have a path to get a remedy. You have a path to get someone in the government to tell the offender to stop using it or to pay you damages. That really wasn't, you were kind of it wasn't cost effective to do before. But with the CCB, now we've got a path. So copyrights are becoming more and more important and more the things that we want to think about. All right, so just to wrap this up, some common mistakes that we want to avoid when we're copyright as a business owner, right? Assuming payment equals ownership, right? If you hire somebody to, write a blog for you, to, create a logo for you, to do some work for you, you might not own what they create. You might only have a license to it, right? So you want to understand what the agreement is. What are you getting? Do you own the copyright? Do they own the copyright? Can they take this away from you? No written agreements at all. Like that's worse than having an agreement that you don't understand, right? You just have a business owner that you're friendly with. The two of you, hey, make a logo for me or take some photos for me for my website. And you don't have a meeting of the minds as to who owns what. That you might lead to disputes, losing control of what you have. I see this a lot. Using content you don't have rights to, right? Hey, I was building my website. I just went on Google Images and I grabbed this. Is that fine? Now I'm getting a letter from somebody threatening me that they're going to sue me or they're going to take me to court. Yeah, other people own copyrights, right? If I take a picture, if I create any kind of content, I own that. So you want to make sure you have permission to use anything that's on your website and your brochures, anything like that. And that includes what you find on Google Images. And then not registering the important works, as we said, writing a book. If you write a book as a lead magnet for your group, you want to make sure that you're registering that. That's something that you want to register, that we want to make sure. So, and if you wait too long, you lose the right to get damages. All right. So that's copyright, right? Now let's talk about trademarks. Okay. Trademarks are about protecting your brand. Okay. What is a brand, right? Let's that little pop quiz. Is your brand your business name, right? Is it your logo? Is it your tagline, right? Is it something else, right? And here's a hint: it's something else. Okay. So what are we talking about? It's your reputation, right? It's your identity and it's the goodwill that you create in the marketplace. I already kind of talked about this a little bit at the overview section, but really it's that reputation you have in the marketplace. Debbie's Cupcakes, it's a bakery and it's the best place to get cupcakes. She does the best cupcakes ever for any kind of party. You want to go to Debbie, right? She worked hard to create that. You work hard in your business to differentiate yourself from your competitors, right? And that's your brand. And trademark protects brand. And I will always like to tell business owners, your brand is your most valuable business asset, right? It is the most valuable thing you have because it is the thing that costs the most time, money, and attention, right? You have worked the hardest to create it. And if someone damages your brand, right, someone steals your brand, it hurts you. And it hurts you in a way that's really hard to get back. So we really want to protect our brand, and we protect our brand with trademark. All right? So a trademark is really a symbol of the source of what you're doing, right? What kind of things can be trademark, right? Anything, right? A trademark can really be anything. And what do I mean by that? It can be words, right? It can be symbols. Most folks understand that. I've got some examples in a second, right? But it can also be sounds, right? It can also be colors, right? I got some examples of that. It can also be things like scents. Play-Doh has their trademark scent. You open that Play-Doh, and you get that baby powder smell as you open up a thing of Play-Doh. They've just recently trademarked a piece of choreography. A company in California that does dance, a certain move. Uh, Usain Bolt, I think, just trademarked his little Usain Bolt move that I won't do. But anything can be a trademark. Anything that shows the public, the consumers, that this is the source of the product or service, right? So let's look at some examples. When we talk about words, it can be the company name, right? We've all know these companies, right? It can be a product name, right? We've all know these products. We all know what company these products come from, right? Without even thinking about it, we all know where iPods come from. It could be a tagline, right? Anything you're using, any system of words that you're using, any word or phrase that you're using to identify your product or service comes through there. It can also be a symbol, right? We know what all of these companies are. We don't need a word, right? We know exactly where these companies are coming from, right? And they've worked hard. They've spent a lot of time, money, and attention. Nike has spent all that time getting that. When I see that swoosh, I know Nike. Not only do I know it's Nike, but I have a good feeling. I'm like, oh, Nike makes really good sneakers and shirts and clothes. And if I see that on something, I have a good feeling about that product. They've spent a lot of time getting it there, right? Combinations of words and symbols, these are very, very popular, right? You see these, where it's the wording in a special font, in a special design, something like that. Even colors, we talked about this. John Deere is my favorite, right? You see that green and yellow, man, you get that good feeling. Oh, that's John Deere. That's got to be quality, right? If you saw a green and yellow toaster in Home Depot, you'd be like, "Ooh, this must be a good toaster." Why? Like John Deere does not make toasters. Why would you? But that good feeling that you have, that's what we're talking about. That's the goodwill. That's the brand. That's what we mean. These red bottom shoes, I can't even say the name of these shoes, but I see these on on some of those entertainment shows or something like that. I'm like, oh, that's the shoes with the red bottoms. Those are really good. Louis Vuitton or something, right? My wife always corrects me and makes fun of me. But that has gotten the color of the bottom of the shoe has gotten programmed into my brain when their company name hasn't even. And granted, I'm not their customer, obviously, but that's how powerful brand can be. And even sounds, right? I put this picture up. I don't have to even play the sound, do I? You heard it in your head, the NBC chimes, right? Boom, 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 right? You hear that, you know, oh, Friends is about to start. Or I'm dating myself a little bit there, but a modern show is about to start. You get excited, right? You get that good feeling you have about the NBC's shows. Just from that sound, right? So all of this can be a trademark. So think about the things in your business, right, that are indicators to your customers, to the marketplace, that your good, your service comes from you and not anybody else. That's what we're talking about when we say trademark. Okay. A couple more things I just want to say on trademark. Federal trademark protection. So much like copyright, as soon as you start using a name, a logo, a symbol, a tagline, a sound, anything, as soon as you start using it in the marketplace to represent your business, you have what we call common law trademark rights. But unlike copyright, common law trademark rights don't do a lot on their own. Really what you want is federal trademark protection. And that's when you get to use the Circle R after your trademark is registered with the federal government through the United States Patent and Trademark Office, the USPTO. That's why you see the Circle R sometimes and you see the TM other times. Circle R means, hey, we've got the stamp of the federal government. We've got the federal government behind us. And that's so much more powerful, right? You have nationwide protection once you get that. Whole country is on notice that this is your mark, back off. You get stronger legal protection. You get access to the federal courts, right? Where the federal laws are very well established and the courts are very well established to this is how we protect trademarks. You do not want to be dealing with the federal courts on trademark infringement. You get what we call enhanced remedies, right? If someone's using your mark, you can get triple damages. It is really a huge stick to get people to back off. And then there's something called incontestability that you get with federal trademark protection that you don't get with common law trademark protection. Incontestability basically means if you register a mark, you use it for 5 years, you file another paper with the USPTO, the Patent and Trademark Office. Basically, they stamp this mark and say, okay, look, this is almost impossible to challenge now. You registered it, you used it for 5 years, you're done. Like it's very, very difficult for anybody to challenge your mark anymore, and it's a very powerful thing that you can have. So we want to get federal trademark protection. Why don't I take a quick stop here? Um, Federal trademark is federal trademark expensive? That's a question. It's not. Oh, I shouldn't say it's not. Sorry, it's not compared to things like patenting. I typically charge $13.50 for a mark, $1,350, and that includes the filing fee, and that's per mark. And for that, I think that's a very good price considering how valuable protecting the mark is. Quick example, we just got, there's a company in Canada, a software company that's they wanted to call themselves IntelliState, which is the name of my law firm, IntelliState Law. I have a federal trademark on IntelliState. And even though they're in Canada, I called them and said, hey, you're doing software. I've got this trademark already through the country. You guys need to rename your company. And they very quickly said, okay, very sorry, we're going to rename our company. If I didn't have that federal trademark, I would have had to completely rebrand everything, right? We've been in business for a few years now, right? I've got not only materials, not only the building, the sign on the building, but everybody in our community knows our name. They know what we're doing. How many tens of thousands of dollars and hours and hours and hours would it have been to reinvent that to start from scratch? So spending $1,300 to make sure that I had that mark, incredibly important. So we want to do that. Any general advice on contract documentation on clients can use when you retain copyright? For example, building training materials for a workshop or 18. Yeah, absolutely. So Aaron, I'm looking at your stuff to give you general guidance. But really what you want to do is uh, you want to have an agreement when you are creating things. So if someone's contracting you to create training materials for a workshop, or you're licensing training materials, you want to have an agreement for what you're doing, and that agreement is going to say, I retain the copyright, right? I'm licensing it to you for this specific, this specific presentation or this specific field of use. And really, you want to work with an attorney to make sure that's in place. Don't use ChatGPT as your lawyer. I've seen too many terrible contracts where we're giving away the farm. And then Megan, your question, I'm sorry, I tagged this in here. This is exactly where trademarking is important, right? If you have your company tag, right? If you've got that trademarked, then we just write them a letter. We write that company a letter that's selling your products on eBay and say, hi, I don't know if you noticed, but we have copyright, we have federal trademark registration, blah, 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 blah. Please stop using that, or we're going to have a judge tell you to stop using that. And they're going to usually back down pretty quickly. And if they don't, then we get some help, and we do that. And then Cindy, you're asking about, can we file the trademark itself? You can file trademarks yourself. And we're going to talk about what you can do yourself and what you shouldn't do yourself. Filing a trademark, I highly recommend, well, let me not even say me. The USPTO highly recommends that you get an attorney to assist you with the trademark filing. You can absolutely do it on your own. There's YouTube videos, there's things. I think it's too important to do on your own, because if you get the wrong trademark, you're going to get into a little bit of trouble. And Megan, I see you adding new trademarks. So I would highly recommend, not just us, I mean, I'm not trying to toot my horn, but there's tons of folks out there that will assist you in filing trademarks. Okay, so I think that's everything. Let me continue here. So common mistakes on trademarks, hopefully get us back on track here. Not performing a registrability search. What do I mean by that? A registrability search is, before you file a trademark, see what other people are using, right? You don't want to start using, you don't want to file an application or start using a mark, and then all of a sudden, you find out a year later, like this company IntelliState in Canada, oh, I've got to change my name. Fortunately, they were at the beginning of their process, but imagine if they were a year into their company and people knew that name and you got to start over, right? You don't want that to happen. It's another reason you want to work with an attorney and not do this by yourself, is because we know how to do those kinds of searches. We know how to advise you on that. Also, selecting a mark that is weak or unregisterable. This is the biggest thing I get with clients. They come with a name that they're in love with, right? But the name might not be a strong trademark, right? And there's certain parameters that I had to kind of cut from this presentation for time. But if a mark is too weak, if it's if it's just generic, if it's just descriptive, it's going to be really tough to get the trademark, even if companies know it already, if customers know it already. So you want help in selecting a mark that's going to be not only registerable, but really defendable in the market. Waiting too long to file for protection, Megan, not to pick on you, but this is exactly a situation that you're in. If you already had a mark, it's going to be a lot easier. Now, it's not too late. We can still file a mark, and you still have what we call common law rights. So but having a mark, way back when, say, hey, I've had this mark for 5 years. That's a much easier cease and desist letter to write than I just filed the mark yesterday. Please stop using it. And then the other thing is believing an LLC or a website provides trademark protection. I see this all the time. I have clients who say, oh, I got the website, I got the URL, no one can use it. Debbie'sCupcakes.com, it's all set. Or I registered with the Secretary of State, Debbie's Cupcakes LLC. I own it, right? You own the LLC name. Yeah, you own the domain name. You don't own it as a trademark. You don't own it as a trademark until you start using it in commerce, right? And then after using it in commerce, you only have the common law rights. So getting the federal rights is really that big stick that helps us defend, right? So this is what I see as trademark things with trademarks. Okay, so that's trademarks. That's copyright. Let me move on to the third item here, which is patents. Patents protect ideas. Remember, I said copyright protects expression, not ideas. Well, patents protect ideas, but what kind of ideas? What are we talking about? And how do they protect ideas? First off, a patent is, at its core, a patent is a bargain that you make with the government, right? You create something new. Novel is the term that we like to use. It's just a fancy word for new. That's how the law wants to do it. So you might hear me say that. You disclose. Disclose means you actually teach, right? How it works to the public, right? So you come up with a brand new idea. You teach the public how it works. The government takes a look at that, your disclosure, right? And it's called the examination process, right? If they think it's new, if they agree with you that this is a new thing, a new product, a new idea, a new way of doing something, you get 20 years. You get 20 years of exclusive rights on that product. And then after that, it goes to the public for everyone to use, right? So it's a bargain. You come up with something that is so important, and you gift it to the world, but in exchange for that gift, you get 20 years the government's going to help you exclude anyone else from using it. So you get like 20 years to essentially make your money, and then you're giving it away for free. That's the deal you're making with a patent. So a couple questions come in. They went away.
Just a comment.
Okay. All right. I'll grab it later here. Okay. So what can be patented, right? A new device, a new tool, a new apparatus, right? A new thing. Most of my clients understand that. I came up with a new kind of grill brush that works better than the old grill brushes. People don't get the little metal spikes, in their food. Really important. Great, new device. Everyone understands that. Let's see if we can patent that. A better way to do or make something. That's the one that seems a little bit harder. But if you come up with a way, to wash a car that's cheaper, uses less water, a different way to make, tires or something like that. Software and systems that are more than just an abstract idea. I could do an entire presentation on just software and system patents. It gets incredibly complicated. No, just for our purposes today, know that you can patent software, and you can patent business methods and systems. It's just very, very difficult. And you really want to work with an experienced attorney on how to do that. A new way to build or structure something, right? Or a novel way to use something, right? These are the kinds of ideas that are really good for patenting, okay? What can't be patented, right? Something that's not new. And this is what we see most of the time. I've got a new kind of girl brush that nobody has ever made before. And then I do what's called a patentability search, and I find 6. I'm like, nope, people have done exactly this before. So it doesn't mean you can't sell it. It just means you can't get a patent. You can't get that protection on that. You can't make that deal with the government because you came up with a new thing first. This one's a little more nebulous, right? Something that's merely an obvious change or a variation, right? Something that is an improvement, but anybody could have thought of that, and that gets into the weeds as to what's obvious, what's non-obvious. Ideas all by themselves, as we said, that's that software business method. An abstract idea can't be patented alone. We need something more. And that's literally what's in the in the legal language is we need something more. What does something more mean? It gets very complicated. But really, it means we're improving the state of the art. We're doing something useful with the idea, and that's really the hard part of filing like a software or business method patent. This one's really relevant for today. When I say today, I don't mean this day, I mean just nowadays, is inventions with no human inventor, right? So something that's purely AI generated. Hey, ChatGPT, tell me how to make this a new kind of, give me a recipe to make a brand new kind of cake or something without an oven. And it gives you something. You can't just file that as a patent if you had no involvement. That's what the patent office is saying. They've been flooded with these ChatGPT inventions, and they're just rejecting them all. Okay, so I thought I had one more bullet. I don't. So really, at the core, most patents are small improvements on existing devices, right? That's really what I want you to think about when you think about patents. Is what's it's not the. I always tell the story of Edison, right? He was working with his team. Light bulbs already existed. A light bulb is the most famous invention in the world, right? It's a typical example. Um, we already had light bulbs. All they did was they came up with a different material to use as the filament, and then did it in a specific shape so that it burned longer and it burned at a light that we could use inside. It wasn't too bright for inside use, right? It was a small but critically important improvement. And that's what invention is. So you don't need to invent like a whole new thing, a slightly better way to do something, a tweak on an existing product, on an existing method, that can be incredibly valuable, right? And that's really what patents are all about. And just I know we're kind of running a little long here, so let me kind of go through this quickly. What I want to take away here is a patent. You have to worry about how strong your patent is, right? We're not just worried about getting through the office. We are worried about getting you rights that are actually enforceable and valuable, right? Right now, the statistics just came out. We're running about 80% patent applications get approved. When you file something, it's about 80% chance it goes approved. That's up from about 50%, I would say about 15 years ago, right? Why? The office has changed their mind. What they're doing is they're focusing on what we call validity. They're basically looking at this patent and says, does this application follow the rules, right? Does it meet these criteria? Okay, we're not going to worry about if it's enforceable, if it's truly novel, if it's worth being a patent or not, right? So validity does not mean your patent is strong or enforceable, right? Validity just means you have a patent. So really, you want a strong patent. You want a patent that has clear and well-defined patent claims, right? That is difficult to work around, right? That covers every key element of your invention, right? We want every detail in there. And we want to be written strategically, not just to get approved, right? So all this is saying is that writing a patent and patent strategy, you really need assistance. And this is the most important part where you need help. This is what you do not want to do on your own. And you definitely don't want to be using these online services that promise that they're going to get you a patent tomorrow. I've cleaned up a lot of those for clients. Because this is the most important part, and you don't get a second chance. Once you make this deal, once you do this disclosure, once you teach the world how your device or your process works, it's out there. And if you didn't do a good job on that patent application and you didn't make it clear and cover all the elements and prepare it strategically, you've missed the boat. You've given away your invention for nothing, right? So it's incredibly important that if you're thinking about patenting, you work with somebody and you make sure that you have a strong patent application. All right, I saw more
Yeah,
comments.
Deborah says she uses Facebook Live to promote her business. There are slogans and phrases that she says that are representative of her business. Is this something that she should be covering?
Yeah, absolutely. If those are things that you're holding out there, you have what we call common law trademark rights on those, but you might consider filing federal trademark on those. So that people can't lift those and use those. And trademarking strategy is something that I do with all of my clients. It's something any trademark attorney is going to do with you. We don't have to we don't have to trademark everything under the sun, right? It's going to be cost prohibitive. right? So really a big part of the analysis is we do a review and we look at everything and we say, I usually give a recommendation. I say, okay, you know what? The name of your business, your logo, and this tagline. I think these are the things I want to protect. I think if we protect those, the rest of your business is covered. So it's kind of a case by case basis, but those are exactly the kinds of things that you want to make sure that you're dealing with. All right. Was there another question in there?
No.
Okay. All right. Common mistakes to avoid in patents. Focusing on just getting a patent, not what it actually protects. As we talked about, you just want to get a number, a patent number to hang on your wall. I mean, that's great. We can be proud, but you really, if you're making this deal, if you're making a deal, you want to make sure you're getting something good back. You want to get good protection back. And that's really what you need to focus on. Trying to cut corners, do it yourself using those online sites. Filing too early with an incomplete application. As I said, once you give up your idea, once you kind of teach this to the world, it's out there. And if you don't have the application done completely and you don't have every element in there, you gave it away for nothing. And it's and it's out there. And then lastly, just not aligning your patent with your business strategy. I see so many clients who come in and they want to patent everything under the sun. My first question to them is, do you have a way to make money if I get you this patent? And if they say no, I say, then we're not filing a patent. There's no reason to get you rights to exclude people from doing this, from making this thing, if you can't make your money back. So just start your business. Just we don't need a patent. So you don't always need a patent. It really depends on your business strategy, and that's when you want to work with somebody on that. All right. All right. So that's patents. The last one I want to talk about, and this one's pretty quick, is trade secrets, right? Trade secrets is kind of like the flip side of patents because trade secrets also protects ideas, right? But sometimes the better way to protect your idea is to just keep your mouth quiet, right? Is to not make a deal with the government, not teach it to the world, just keep it quiet, like Coca-Cola, like KFC and their herbs and spices, right? Just protect it by keeping it secret, right? So what is trade secret? It's really anything that gives your business an advantage, right? I have a special way that I can bake my cupcakes. It makes them way more good and half the calories, right? If nobody can figure that out, there's no reason to tell anybody. If nobody can reverse engineer how you're making those cupcakes, you're all set, right? As long as it's now the flip side of that is if any bakery can just take one of these cupcakes and figure exactly what you did, then we need the patent to protect you because that's going to give you that stick, that property right to protect you. But if nobody's going to be able to figure out the secret ingredient to your cupcakes that make them taste amazing and be half the calories, then we don't need to worry about that. You're only protected if you actively keep it confidential. That's the other half of trade secret, okay? Is you have to take what we call reasonable measures. You have to protect your trade secret. If one of your employees, steals that cupcake recipe and starts her own cupcake business, we sue her for violating trade secret. If she says, well, look, they took no steps to protect the recipe. It was just out on the counter. I heard the owner talking to customers about it. Everybody knows this. If they didn't do a good job keeping it a secret, then that person wins, right? So you have to take those steps, those reasonable steps to keep your trade secrets confidential. That's the most important part about trade secret, okay? So you want to limit who has access, right? You want to use things like confidentiality agreements, NDAs. If you are talking to people, if you are having employees that are doing that recipe, they're using those, right? And the reasonable measure, that's the standard to protect the information, okay? So trade secrets is really something you can mostly do yourself, right? And it's really about keeping things secret, having NDAs, having good confidentiality documentation in place is a good rule anyway. But the common mistakes I see, just not treating the information as valuable, not protecting that recipe, not protecting that know-how. Not having NDAs in place, or and I could have put on here, having ChatGPT write your NDA. Don't do that. ChatGPT talks a good game, but it is not a replacement for someone who actually knows how to write an NDA. So work with somebody, get a solid NDA in place for your employees, for any of your vendors, anybody that you're working with, anyone you're giving confidential information to. It's not hard. It doesn't cost a lot. You can do a simple agreement and then use it with everyone. Sharing too freely. I see more comments. I'm going to grab those. Let me go finish these and I'll get back to the questions. Sharing too freely with employees, right? Without, taking care of those things. And then I'm going to lose the comments. Okay, let me actually do the comments and then we'll come back. Um,
Well, the first
so,
one is, yeah, what do you do when you have to include the ingredients on the bottle?
oh, that's such a great idea. So in that case, right, that's an idea where we could. So cupcakes was a terrible example. I apologize. When you have to include the ingredients on the bottle, we can't use trade secret, right? Because the law says I need to tell everyone what's in here, right? So that case we need patent protection, right? Or um, you don't always need patent protection. You don't always need trade secret. A lot of times the strategy might just be first to the market. Protect it, get out there, use your reputation, use trademark to sort of protect your rules. So not everything falls into the trade secret because if you can't keep it secret, that's a really good point. Trade secret doesn't work. You can tell I come from tech and not from baking because I just didn't do that. And then here to clarify, is this something you would file with the government or something you want to talk about? Carl, if you mean trade secret, yeah, you don't file it with the government. You don't list what a trade secret is. And I can hear my staff screaming because I know what story I'm about to tell, and I won't do it because we don't have time. But when you actually have to enforce a trade secret, you then have to disclose it to the court, which seems to undermine the entire point of keeping something a trade secret. So I won't say more about that other than that's a factor that goes into the strategy, whether we patent something or trade secret something. If we do have to enforce this, we do have to get it out there. All right. So I think I have one more of these. If I can get back to here. Yep. And then assuming you're automatically protected, right? Assuming that there's no protection unless you maintain active secrecy, right? You've got to actually do a little bit. You've got to actually take those reasonable steps. So that's what I see with trade secret. All right. So just a couple wrap up here to put it all together. I want you to think about intellectual property functioning in your business, right? You build it, you create something of value, right? You protect it. You use one of the four methods to protect that IP, whatever's appropriate, right? And then you keep it. You've got the ownership, you've got the timing, and you're controlling those things, those very valuable elements of your business. That's how I want you to think about it. You've built something valuable. Let's find a way to protect it, and let's find a way to keep it that's ours, right? That's how I want you to think about IP. Okay. Most owners focus on the building, right? I made up a new blog article that I'm writing or a new product that I'm going to sell. I did all of that work, and they skipped the part about how to protect what they built, right? You wouldn't leave your company van in the parking lot with the keys on the dash, right? You wouldn't leave your building open so everyone can come in and get the computers. Your IP is just as valuable, maybe even more valuable, depending on your business, right? So how I want you to think about intellectual property, I want you to focus on what creates value in your business, whether that's your name, your slogan, whether that's your product, whether that's the copy, the printed material you're creating, the content that you're creating on your websites. What's creating value, right? Use the right tool to protect it, right? And then take steps early to protect it. Don't wait until there's a problem. Don't wait till somebody's on eBay selling your product using your name. Have those positions in place first. Okay. When and how to act. Copyright, you want to mark everything as soon as you create it, and you want to register the key works, right? So you don't have to register everything as we said, but you want to register before you have to enforce. Trademark, you want to work with an attorney to search, strategize, and register. You don't want to just come up with the name that you came up with at the kitchen table and without thinking about it further. You're going to be putting a lot of money, a lot of time, a lot of effort into promoting your brand. You want one that's protectable. So you want to trademark before you start investing in this branding. Let me jump in here. Content like poems, that's copyright. So Deborah's asking, how do we protect written content like poems? Register where? You register that with the Copyright Office, and they have a website, copyright.gov. I think, yeah, copyrightsingular.gov, I believe. And you can register it there. You can register on your own if it's something like a poem, if something like a book, that's pretty straightforward. But if it gets more complicated, if it's software, if there's multiple types of copyright, if it's something that's going to be changing a lot, A lot of times I'll advise folks to work with an attorney just because you can have a strategy. Like you can file a bulk of copyright things together under one fee. A bulk of works if they're related together, and that gets a little bit into the weeds of how we do that. Um, but a lot of times working with an attorney is just a good way, especially if these poems are something that you're going to actually be monetizing, selling. That's where you protect it. All right. Okay, I think we got that too. All right. So I'm going to keep going here. So patents. Um, Patents, 1,000% work with an attorney on any patent. Okay. The other three, I mean, trademarks, I do want you to work with an attorney, but you can maybe get away with, looking at some YouTube videos. I don't recommend it. Patents, I am begging you, if you take nothing, do not file your own patent. Do not use one of these online invent help type websites that trick people into filing patents. It's too important, right? So, and you want to do this before any public disclosure, okay, on patenting, before you start going to trade shows and bragging about how amazing your new grill brush is, before you start doing talking to potential investors, before you start doing anything, we want to secure the invention. And there's ways to do that very cost effectively first as a placeholder, then go get funding, then come back and file the real patent application. It's going to cost a lot more money. There's ways to do that. You want to work with an attorney on a strategy and a plan to do that. And then trade secret. How do we use NDAs? So use NDAs, take limited access, take what we call the reasonable measures, right? And do this before you share any information with other folks, right? So that's really kind of the takeaway. This slide is kind of like the takeaway of how to address the four ones. We got a new question came in from Megan. Is it best to copyright a slogan, copyright a slogan and trademark? No. No, let me make this clear. So Megan's asking if a slogan is something we copyright and a business name is something we trademark. They're protecting different aspects. You don't really copyright a slogan because it's not really expression, right? You might copyright an article that you wrote or a book that you wrote, or a guide to doing something. You trademark anything that's a symbol of your business. So just do it, right? If I say just do it, you know exactly what company I'm talking about, right? And you're getting a feeling of like, yeah, I want to kind of get out. Maybe I should sign up for that 5K, right? Oh yeah, yeah. They've programmed that into you, right? That goodwill, that business idea that makes you want to go buy sneakers, right? So that's why that's a trademark, right? If Nike wrote an article on the best way to sort of prep for a 5K and then the diet to use and the things like that, that's something that's copyrighted, right? That's expression, right? So slogans, logos, names, product names, sounds, these are symbols of a business. That's where we have trademark. Expression, creative content, that's copyright. Copyright, Cindy asked if it's easy to copyright. Yes. I shouldn't say that. It's much easier to copyright than it is to file a patent or a trademark. There are still steps that we need to go through. But copyright is the one I feel most safe having you do on your own. That said, I still have a lot of clients. If it's something very valuable and you want to register it, working with attorneys is a good idea. But there's a lot of really helpful guides on the copyright website, copyright.gov. And they've actually got some really nice like cartoon shows and videos where they walk you through exactly what to do. A book, absolutely. A book, you just want to you file up. I'm sorry, Cindy just asked if a book will use it. Yeah, and that's very easy to do. You can actually just go to copyright.gov, follow the guide there on how to do it for a book. And you're all set. A book I would, Cindy, encourage you to do on your own. But I'm going to have my business card slide at the end of this. Feel free to follow up with me afterwards, and I'm happy to talk about it a little bit more. Megan's asking if we can trademark 3 things on one application. Unfortunately, no. Megan, every trademark is its own application. If you actually look at the bottom of my slide here, you can't see my mouse. Oh, yes, you can. All right, down here. IntelliState Law here, this is one trademark. I have a second mark where I don't have any words. That is a completely separate application that I had to file. And then IntelliState Law, the words by themselves, that's a third application I had to file. So every variation is a separate mark.
Hey, I got another question that came in through Q&A.
Sure.
In self-publishing on Amazon, ISBN is generated for a book and copyright resides with the author. Is there more authors need to do?
Um, I haven't looked at, I don't want to give, well, I'm not giving legal advice, so that I'm covered there. Remind you, I'm not giving legal advice. I have not looked at the Amazon terms of service. So I don't know if there's any gotchas in there, but they're registering with the ISBN. That's important. And you own the copyright. I don't know if they're registering the copyright for you or not. Um, and they may be saying you should get a registration number from the copyright if you do that, and you can look it up on copyright.gov and see if you're there. Um, I don't know if Amazon's the self-publishing service does that for you or not. Long way of saying I'm not sure. But hopefully you understand the difference now between just having, copyright and actually registering your copyright. But for a book, you want to do it. Um, I will say on a book, though, every time you change something, you have to file a new copyright. So you kind of want to do the last version. And that's where you kind of want to work with somebody to make sure that you're doing those things. All
Okay.
right, so this
Yeah.
is our information. Oh, geez, I went a little bit over. I apologize. Oh, 101, that's not that bad. My clock in my office is fast. Okay. If you need more information, if you want to know more, feel free to reach out. Happy to talk with folks on how we do things. This was a lot. This was a lot of information. As I said, I usually do one of these in a presentation, not all four. But I wanted to just give you from a business owner's perspective, owner's perspective, what you need to know. There's a lot more to know. Okay, so this was really fun. Thank you to Boston Business Mentors for letting me do this. I'm always happy to talk more.
Okay. And I just wanted to quickly throw up our thank you slide. There is that QR code to request a Boston Business Mentor that you can use to quickly connect and reach out to us with any questions you have, and we will help you connect us to the right person, the right resources. Thank you, everyone. Thank you, Jason, and have a great rest of your day, everybody.
All right, see you, everyone.